In this video, I'm going to talk about why we think that the Swedish government unlawfully took away our daughter. First, I would like to say orally, they made a lot of false statements to us. Orally, they claimed that they took away our child because we were unable to establish the biological parental relationships, so that they worried that we were not the girl's parents, so that they had to take away our daughter Lily for the social care. She was taken to our family for care. But then we received more documents when we were released from the police detention. In total, we received two relevant documents. The first one is issued by the police authority. It is children's best interest assessment. It's telling why they think that the child should be put to a care family. And then another document is issued by the Linköping Social Authority. It basically said that which law they invoked to take away our child. For the written document, the reason was very different from the oral one I've got. On the children's best interest assessment, they mainly said because my wife and I refused to talk about who the child was, and then we also refused to recognize the child as our child. So they thought that the child was under no one's supervision, no parents, no guardian. So they invoked Section 3 of Chapter 10 of the Aliens Act to take care of our daughter. But then what they said was totally untrue. When we first caught by the police, we immediately showed our IDs, our passports to the police, and then told them the little girl was our child. When the social workers came, we also clearly told them we are the parents of the child, and then we did not authorize them to take away. Interestingly, if you look at the Section 3 of Chapter 10 of the Aliens Act, it is a Parliament Act of Sweden. If you look at it, the first sentence says that the child shouldn't be taken care if they are with their parents or guardians. So they they said that we did not say anything. It's untrue. And then the second sentence was that the child can only be taken into care by the social authority when the child was unaccompanied or found without any parents or guardian. So the reason was untrue. Okay, now I talk about the social welfare documents. Then they invoked Children's Protection Act Section 2 to take away our child. What is Section 2 about? Section 2 says that the child can be taken away if it has evidence to show that their parents or their guardians obviously is harming to the child. For example, if the child is negatively affected psychologically and then physically, or exploited, or be made vulnerable. This is a very serious accusation. If they would like to invoke this legislation, they have to have strong evidence. But so far, I have not been offered any evidence to say that we have wrongdoing on our child, or we made them scar, or they discovered some secret scars that we could not explain. No, nothing. So that I wrote to the court and explained why the social authority is wrong. First, I invoke Article 8 of the European Convention on Human Rights. Article 8 protects the family relationship and family bond. In many judgments, the European Court of Human Rights reaffirmed that a state has the positive obligation to maintain the family bond and family relationship. Also, according to Article 3 of the Convention on the Rights of the child has the best interest. When you make a decision with regard to a child, you must you must hear what they say. If you do not understand what they say, then you have to ask someone close to her to tell the authority what to do. So when they separate the child from us, apparently it is not the wish of the child. It apparently they did not listen to us how to interpret what our child's wish. Our child is only 2 years, so she couldn't say anything. But we as their parents understood her very well so that we could interpret, but we were not offered any opportunity to tell anything.
Also, when the child was taken away, she cried, she screamed, she was nervous. It is also what the social worker said in our last telephone conversation. So apparently, there is some bonding between my daughter and me.
Okay, let's see also about the international law, how they defined what parents is. According to Article 9 of the Convention on the Rights of Childs, the child has a right to be with their family members, their parents. So what is a parents? In the immigration context, if you found that someone holds custody, legal or customary primary caregivers and foster parents, and then parents with whom the child has a strong personal relationship. This is what General Comment Number 14 issued by the Committee on the Rights of Child says. It means that parents is not restricted to biological parents. It's also someone who hold the custody, who takes care of the children, and then whose foster parents, or you can apparently say someone whose affection is very important to the child. So biological relationship is not a definitive element to define what a parent is. The most important is someone is with them. They have a strong relation, strong affection connection.
And when we were detained at the police station, our DNA was taken. It was one of the coercive measures. So the police actually get hold of our DNA, and my husband actually suggested gave his consent to the social workers to match his DNA with the DNA of our daughter. But apparently they didn't do it, and they refused to do it and say that we didn't recognize our daughter, and say that the biological relationship cannot be established, while actually the biological parental relationship is not crucial for identifying the parent, this term in the legal context.
Yes, I already offered my consent on the 7th of December 2023, but then they did nothing until now. Now it is 16 December. Yeah, just like previously I said, they invoked the social authority invoked Section 2 of the Act with special provisions on the care of young people. This act, the social worker had to really show the signs that the child's got some kind of injury abuse. But then so far I have not received any information saying that they have any scar or vulnerabilities made by us.
Also, when my daughter was forcefully taken away, the social workers told me that she would see her daughter. And then I said to them, I want to see the doctor with them. And I was refused.
Finally, let's not talk about the legality about taking away my daughter. Even if they have a power to do so, at least we have a right to visit or to contact our daughter. 2 years ago, the European Court of Human Rights made an adjudication in a similar case. It is Deltunva versus Lithuania. The case number is 38144 /20. The situation was a bit similar to us. It was about a child whose state refused. A child father was in a jail, but then the state refused him to be visited by her daughter, and then refused to offer a phone call to her daughter. So finally, the court adjudicated that the state was in breach of Article 8 of the European Convention of Human Rights. The court decided that even if a detained person or a prisoner, they have a right to be visited and contact with their relatives. Minimally, a detainee should receive 1 hour physical visit of their child, and then also 1 hour of phone talking, 1 hour per week. So from now on, it's been 10 days. We have not been offered any contact or physical visits. So it's apparently in breach of our rights under Article 8 of the European Convention on Human Rights.
We appeal so far. We have appealed from 2 courts. The Stockholm court has already managed our case, and that's why we are now set free. And the investigation is complete. It's ceased already. We now have freedom again. However, the Administrative Court of Linköping has not given us any replies in how they are going to handle this case. We are very worried because we don't actually know the accurate information of our daughter at all. We suspect that our daughter has come across something very bad, and that's why they want to hide their negligence. And maybe my daughter is receiving some secret treatment. We are very worried. So I hope you guys can help us. Actually, in the past 2 years, we have gone through many legal proceedings internationally: Finland, England, and international courts, ICCPR, ECHR, and they all of them didn't give us a fair judgment or a legal remedy. So we are very disappointed with the legal systems. I'm not very optimistic with how Linköping will deal with the case. So instead, I would love to seek your help to watch my video, to understand our situation, to spread our video. Please comment and reply and share. I hope our story will try to not only protect our family, but also families out there facing unfair treatment by the courts too.
Yeah. Our case is not a single case. It is systematic in Sweden, we believe.
Yes. Thank you very much.